Let's take a look at what the FMLA requires. The FMLA requires that employers provide the following to eligible employees who experience qualifying events. Up to a total of 12 work weeks of leave over a 12-month period, when the qualifying event is the serious injury or illness of a service member incurred during active duty. The maximum period of leave is extended to 26 weeks. Maintenance of health insurance under the same conditions as if the employee had not taken leave. Restoration to the same position held before leave commenced or to an equivalent position with the same pay, benefits, and other terms and conditions of employment. These three core requirements reinforce one another. The right to take leave would be rendered meaningless if employees did not retain their health insurance. Likewise, the promise of a right to take leave would be illusory if employees had to take leave without a reasonable guarantee that their jobs would still be there upon returning from leave. These employee rights are supported by requirements that employers must refrain from discriminating against employees for taking FMLA leave and from otherwise interfering with, restraining, or denying the exercise of FMLA rights. Generally, employer actions that delay or deny the leave give rise to interference claims, while actions taken by employers during or after periods of leave to punish leave takers constitute retaliation. Although both violate the FMLA, the distinction between interference and retaliation is important because a legal motive must be shown in retaliation claims, while the employer's reasons for interfering with FMLA rights do not matter. Decisions adversely affecting employees who've requested FMLA leave, who are on leave, or who have recently returned from leave should be very closely scrutinized. A common issue in FMLA cases is employees being disciplined or terminated based on absences due to FMLA leave. Employers must not base adverse employment actions on the taking of FMLA leave. The FMLA creates an entitlement to leave. If an eligible employee experiences a qualifying event and notifies her employer that she needs to take leave, the employer must grant the amount of leave needed. Employers have four options for determining the 12-month period. It could be the calendar year, any other fixed 12-month period, a 12-month period measured from the first day of leave, or a rolling 12-month period. The latter two methods are more complex but prevent employees from stacking periods of leave on top of one another. Employers must adopt one of these methods and use it consistently, and notify employees regarding of their choice of method. Although employers can require employees to comply with reasonable policies applied to ensure that leaves are not being abused, employers are not free to assign work duties to employees on FMLA leave. Depending on which qualifying event necessitated leave, it may be taken consistently or continuously or intermittently, which consists of period of leaves mixed with periods of work. Leaves for childbirth, adoption, or foster care placement must be continuous unless the employer allows otherwise. Leaves for serious health conditions of employees or family members can be either depending on employee need. A critical issue for employees is whether the time off from work comes with pay. Under the FMLA, employees may choose or their employers may require them to substitute available paid leave for unpaid FMLA leave. Any paid leave that is substituted must fit the qualifying event that necessitated FMLA leave and any other neutral requirements of the employer's normal leave policy. The FMLA specifically requires that health benefits be maintained under the same conditions that would pertain if the employee did not take leave, such as the coverage level and employer contribution. On return from FMLA leave, an employee must be restored to the same position held when the leave was taken, or to a position that is equivalent in pay, benefits, terms, and conditions of employment. Taking leave does not immunize an employee from a layoff or termination that would have occurred anyway. There is a narrow exception to the restoration requirement when a key employee takes leave. A key employee is salaried and among the top 10% of the company's earners. They must be informed of their status when they seek leave. If the employer decides that their restoration would cause substantial or grievous economic injury, they should be given a reasonable amount of time to return from leave.